Hello, welcome to Lawyer Explaining. Today I'm going to explain the process after you're arrested and the judicial process that happens after that. So, starting with the probable cause for your arrest, if it's a felony charge, the first thing you do is go to bond court in front of a judge. The judge will base your bond dependent on your criminal background, the charges against you, and how many times, whether you've missed court in the past and whether you're a flight risk. The judge can give you a recognizance bond and release you without having to post, or they can set a monetary bail where you would typically post 10%, or depending on the state you're in, you might have to go to bail bonds if you can't post that. Or they can give you a no bond if the charges are serious enough. Now, the next step after that is the preliminary hearing or indictment. Now, the prosecutor typically has 60 days under speedy trial to either indict you or have a preliminary hearing. Now, a preliminary hearing is in front of the judge with your defense attorney and the prosecutor, where it's just trying to show prove probable cause, whether there's enough to charge you. This is not based on beyond a reasonable doubt. It's just whether there was enough probable cause to proceed with the charges. 99.9% of the time, they find probable cause. It's not a very heavy burden for the state to pass. If they do find probable cause, the next step after that is the arraignment, which I'll get to in a moment. The second way, besides the preliminary hearing, which must be held within 60 days, is being indicted. Now, indictment is just another probable cause hearing, but it's done with a grand jury, which is people picked from the community, just like a regular jury that would be a trial. But in this instance, the grand jury gets to look at the facts of the case, and they determine probable cause, not the judge. When this is brought down, it's called, if they do decide probable cause to proceed with the charges, they bring down what's called a true bill of indictment. And and 99% of the time, they also find probable cause. Now, just because they find probable cause does not determine how successful this would be at trial or the remainder of the case. So it's very easy for the grand jury to find probable cause. In fact, hearsay is allowed, which is typically not allowed in the trial court. And also the defense attorney and the defendant are not permitted within the grand jury proceedings, so it's pretty much they can do whatever they want in there. Once probable cause is determined, either through the indictment or the preliminary hearing, the next step is called the arraignment, which is usually held a week or two after probable cause has been found. Now, the arraignment is simply just a formal reading of the charges against you. So you would formally find out all the charges. Initial discovery would be tendered from the prosecutor to your defense attorney. The only thing that typically wouldn't be in there are, maybe if it's a drug case, laboratory reports, anything that would take a little longer, or anything that was delayed. They don't have to have that right away. But the initial indictment and the charging document is given on that day too, so you know officially what you're dealing with. After that, there'd be typically a little bit of time for discovery, the next court date or two, where the prosecutor and the defense attorney are sending discovery and discovery requests and subpoenas to each other and getting all the paperwork out of the way before they determine what's going to happen. Usually after the discovery is tendered and the defense attorney has a little bit of time to look everything over, then now would be the time for motions. Any motions to suppress, motions to dismiss, anything that the attorney feels might be dispositive in the case in order to get the case thrown out or get some evidence suppressed. That way it won't be available at trial. Depending on whether it's successful, it might dispose of the whole case and get it thrown out, or it might just assist in the defense at trial by minimizing what the state gets to use against you. If you can come to a plea deal based on how much evidence there is or how much evidence has been suppressed, there might be a better deal to be had. If nothing can be done with that, the next step would be setting it for trial. Now, at the trial is when it's determined your guilt beyond a reasonable doubt. You have a choice of a bench trial, which is when you let the judge determine whether or not you should be found guilty or not. He makes the decisions. Or you have a right to a jury trial, a jury of your peers, your constitutional right to a jury, and they would determine your guilt beyond a reasonable doubt. Depending on the type of case and the facts, whether you want a bench trial or a jury trial, all depends on the history of the attorney, how they feel about the case. Typically, if it's a legal issue that's disputed, you would want the judge, you would want a bench trial to let the judge determine, because it's a legal issue or a technical issue. They know the law a little better than a jury would. And so if you think that that's in your favor, you would want to request a bench trial because it's the defendant's right to a jury. But if they don't want the jury, they can waive the jury and request the judge hold the trial instead. When you want a jury trial is when it's more of an emotional verdict that you're looking for, a case where you want them to feel bad for you or look at your defense and try and understand what you went through, something like that, and hopefully to get a favorable verdict in that case. So but it's based on the attorney's history, the facts of the case. Every case is completely different, so you can't determine, just say this kind of case you want a jury, this kind you don't. It's kind of just have to base it on the attorney's knowledge and skill with that.